Module Overview. The formation and sustainability of political parties are governed not only by societal demand for representation or ideological pluralism, but also by the institutional and legal frameworks that regulate party existence. Political parties, though not always constitutionally mandated, are often treated as indispensable actors in democratic governance, shaping policy direction, contesting elections, and serving as a bridge between the government and the governed. This module explores how legal instruments, constitutional mandates, political finance laws, registration rules, internal democracy requirements, and regulatory agencies influence the creation, evolution, and operations of political parties. It delves into comparative global frameworks, judicial reviews, anti-defection laws, electoral laws, and party dissolution mechanisms. The legal recognition of political parties. A. Constitutional and legal status. In some countries, political parties are constitutionally recognized, e.g. Germany, South Africa, while in others, they operate primarily under electoral laws or statutory instruments. The Constitution may guarantee freedom of association, allowing citizens to form parties, outline requirements for party formation, regulate the ideological foundation or conduct of parties, ban ethnic, religious, or regional parties. B. Political party registration requirements. Many countries require parties to be registered with an independent electoral commission, meet minimum membership thresholds, e.g. national spread, possess written constitutions and manifestos, abide by internal democracy, including fair primaries. These requirements aim to prevent frivolous or ethnically divisive parties, ensure party accountability, and regulate their role in the democratic process. Party law and regulation. A. Legal instruments governing parties. Party laws may regulate sources and limits of campaign financing, annual disclosure of funds and donations, membership recruitment practices, gender representation, e.g. gender quotas, limits on foreign support, party symbols, names, and registration guidelines. B. Independent electoral commissions. These commissions monitor party registration campaign, conduct candidate nominations, internal democracy compliance, election spending. Example: Nigeria's Independent National Electoral Commission, South Africa's Independent Electoral Commission, India's Election Commission. Internal democracy and governance in political parties. A politically healthy democracy requires that political parties themselves uphold democratic principles internally. Key areas include transparent and inclusive candidate nomination processes, democratic elections of party leaders and executives, accessible dispute resolution mechanisms, fair representation of women, youth, and minorities, accountability and term limits. Failure to observe internal democracy can lead to party factions, defections, or legal disqualification, undermine public trust in political institutions, weaken policy innovation and ideological clarity. Anti-defection laws and party discipline. Anti-defection laws are designed to prevent elected politicians from changing party affiliation after elections, thereby preserving the integrity of the electoral mandate. Examples: India's 10th Schedule, 1985, disqualifies MPs, MLAs for defection. Nigeria's 1999 Constitution, Section 68G, allows for loss of seat except in cases of party mergers or splits. South Africa once allowed floor crossing, but later banned it due to abuse. Critics argue anti-defection laws limit freedom of conscience and expression, empower party elites, and suppress dissent. Supporters say they promote party stability and discipline, respect voter mandate. Political finance and transparency regulations. Money plays a powerful role in politics, and unregulated finance can lead to corruption, unequal competition, and elite domination. Legal frameworks often address spending limits during campaigns, donation caps, individual, corporate, foreign, Public funding, subsidies to political parties, e.g., Germany, Sweden. Mandatory disclosure of donors and expenditures. Auditing of political accounts. Enforcement mechanisms may include fines, withdrawal of party registration, disqualification from elections, bans, suspensions, and party dissolution. Governments may ban or dissolve political parties under specific legal circumstances, such as promotion of violence, terrorism, or hate speech. Links to foreign powers. Failure to meet legal registration obligations. Non-compliance with electoral laws. While such provisions are sometimes necessary for national security, they may also be abused by authoritarian regimes to suppress dissent and eliminate opposition parties. Comparative frameworks. In this section, we will be using country, legal party registration requirements, funding regulation, and party law notes in our table. First, Nigeria must have national spread, register with INEC donation caps, annual audit anti-defection law, party primaries monitored second. Germany constitutional protection of parties. Public subsidies plus donation limits must be democratic in internal structure. 3. India register with ECI, must contest elections, expenditure caps, party symbol laws, 10th schedule on defection 4. South Africa IEC oversees parties, party list system, transparent funding laws, proportional system encourages inclusiveness. 8th, legal challenges and controversies. Politically motivated deregistration of parties, unequal enforcement of campaign finance laws, manipulation of internal democracy rules, delays in auditing and weak judicial enforcement, tensions between party autonomy and state regulation. Importance of a robust legal framework. A sound legal framework ensures fair competition, encourages ideologically coherent and stable parties, increases transparency and accountability, builds trust in the electoral system, strengthens democratic resilience. However, such laws must balance regulation with freedom, prevent abuse, and adapt to evolving political realities.